Thanks for joining this episode of the number 86 lecture series, in which Professor Richard Epstein discusses property rules in the Roman law. In episode 2, Professor Epstein explains how the Romans thought about private property, how modern private property rights compare to the Roman system, who could own property in the Roman world. This lecture is part of a series with Professor Epstein on how this ancient legal system can provide crucial insights about modern problems. Professor Epstein is one of the most prominent legal scholars of our day. He is the inaugural Laurence A. Tisch Professor of Law at NYU School of Law, a senior fellow at the Hoover Institution, and Professor of Law Emeritus and a senior lecturer at the University of Chicago. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
In our prior episode on Roman property law, you discussed the principles of common property. But when most people think of property, they immediately think about private property instead. What is the foundation for private property? Was it understood differently in the Roman law?
So when you start looking at the way in which the agricultural system works, there's the following maxim which appears everywhere, which is you're only allowed to reap where you have sown. Now, why is this? Because it's an agricultural metaphor. And what this means, in effect, is that if you take all of the effort to clear this land, to plant, to water, and so forth, backbreaking labor, and somebody else is entitled to harvest it, you will never have the incentive to plant, and therefore because other people can take it away. So now you have to have long property rights in land. But before agriculture, you never had this. So in a hunter-gatherer society, before the Roman times, what you would do is you would go into an area, you had no front-end cost. You'd hunt the game until it extinguished. That was the job of the men. You'd gather the fruit until it was exhausted. That was the job of the women. And then the hunters and the gatherers would move on to another location. And if you had sufficiently sparse populations in these areas, you could sustain them all. Sure enough, as the groups start to get larger, it's more difficult for them to move. They have to take larger territories. Two such groups start to come into contact with one another. You're going to have a bloody fray as to which of them is going to be able to keep the common land or not. But you're not going to have agriculture. You don't get property rights in agriculture, in land, until you get agriculture. But you do have strong property rights in chattels, animals, and so forth, because those are things that you invest with and take with you when you start to move. So when you got getting to the land situation and you now have agriculture, then you have to make it as a kind of a permanent system. And so you start to ask yourself, which of the two problems is greater? The problem of holdout on the one hand or the problem of externality on the other? And if you're talking about most plots of land, relatively small in squares, I can take mine and farm it. You can take yours and farm it. And it's not like a river where if I take something out of the common area, everybody else is necessarily harmed. There's enough and again as good. Take some other land and do it. So these people start to come up near one another. Generally speaking, it turns out most people preferred to have neighbors than to be alone, because just taken in the simple geometric situation, suppose you just have two people and you put them isolated. Each of them in a square will have four borders that they have to protect against, and they have to do it alone. If you put them together, now you've got two things, and it turns out one of these borders is in common. So each of them only has to defend three borders instead of four borders in this simple construction. And they also have an ally with which they can do this. And so essentially what happens with territories is people want to have neighbors. In the beginning, the neighbors turn out to be family members and kin and so forth. It's not just two people, it's four people. And if you start doing that particular element, what happens is you get four people in there. Instead of having 16 boundary lines, what you do is you have 8 boundary lines. So you have 4 people protecting half the perf that you otherwise had. And it's quite clear that there's a natural advantage in having some neighbors. As the states have to get bigger, you can't base this on clans. So then you have to create a notion of citizenship so as to allow outsiders in. You may have separate properties, but a common wall. The Romans were very careful about their wall rules. Essentially, a wall was public property, but it wasn't like a river to which everybody had access. It was a form of public property which was called a res sancti, a sacred thing. And what that meant, in effect, is that nobody could subdivide and take his part of the wall out, at which point the enemies could run you over. And so it was done. But the logic of putting a wall around the town is exactly the logic of going from one plot of land to 4 plots of land, is you have a larger core of productive activities and a smaller perimeter surrounding it. This is geometry. It's nothing else. And so these kinds of relationships exist and survive in every culture at every time. When you start trying to have fortifications and land, what you do is you have a core. The core must have water so as to survive as siege. And then you have the fields outside the land, which you can till in good times and then retreat back with your stores of water and grain in hard times to withstand the siege. So you tend to build the town on a higher piece of land, so the guys are having to shoot up instead of down. And you can see a universal pattern.
How are these principles manifest in modern times? What do private property rights look like now?
And what happens is we now have private property rights in land. We have neighbors. Why do we make them private? Because suppose it turns out that these things are open to others. I plant seed on Monday, and Tuesday somebody decides to have a drag race across my property. It means that I do not have the exclusive right to keep them out, which means that we will never have the growth. So what takes place in every legal system known in the world is the moment it turns out that the coordination problems are not important, but the externality problems, the nuisances and trespasses of other married, we move to a system of exclusive rights as the first approximation. And that's the way it's been in every culture. And so what you then do is you have to worry about how you police the boundaries. Now, this, of course, is going to create serious problems of its own, because just as with the water cases, the bound where the river was not an absolute, you had all these complicated rules, right, about taking water out for the use of the breach on time of necessity. Same thing is going to happen with respect to land. The boundaries are going to be fuzzy. And so you start to develop all sorts of obligations associated with the law of nuisance. I can't throw my filth on your land. You can't fell the roof on my land. Well, do we want this to apply to every noise and peep we make? That's just absolutely indefensible, because there'd be no production and too much interference. So we developed what is known as the live and let live rule, which was certainly part of the Roman system. And that meant, in effect, that I can talk on my land even if you could hear the noise, and you could talk on your land even though I could hear the noise, because we were all better off with these minimal invasions than we were with another system. And this kind of pattern of behavior, de minimis non curat lex, the law does not concern itself with trifles, is a universal feature of all systems about land law. The absolute boundaries when you have fixed neighbors cannot be observed, whereas when you're talking about chattels, which you can take from your porch in the front of the house and move it in there, you can say to somebody, don't mess your hand around with my watch, with my vase, with my tables, and so forth. You don't have the same problem of physical adjacencies that you have with land, which requires that you soften things at the border. So then there become obligations of support. I can't dig out to the garden of my land and have your land fall over. You can't do the same thing. But on the other hand, if you want to build on your land, I don't have to support the improvement. What I have to do is to give you notice that I'm about to take this stuff out so you can shore it up, so long as I leave enough in there so that the land itself doesn't fall out. These rules were surely implicit in the Roman system, but we don't have much explicit stuff about them. They become articulated most clearly and powerfully in England in the 1860s, chiefly by Baron Bramwell, who wrote the famous decisions on the live and let live rules associated with a case called Bamford and Turnley, which was decided around 1860. So again, it's the perfect continuity and shift about the way in which land works. So the rules have to be exactly the opposite.
You just mentioned that a lot of these property rules are not explicit in the Roman system. Why is that? Did the Romans think that private property usage was less important than common public property?
I spent a good deal of time talking about the difference between common and private property under Roman law, or as they would call it, the res commune, that which is open to all, and the res nullius, that which is owned by nobody until somebody acquires access to it. If you then look past the first page or two, which announces this distinction, what you discover is that virtually all of the attention that the Romans pay is to the private law side of the issue. And it's important to understand that this is not some kind of omission, but rather it necessarily follows from the way in which these two systems are organized. If you're talking about a public space and so forth, to which everybody has access, And nobody has to enter into any particular transaction in order to get into that space. And so what generally happens is the system begins and ends by a notion that everybody's entitled to access to this, that, or the other thing. And you're not going to have to buy access. You can't sell access. It turns out you can have service contract related to the way in which you run on a river, but those are going to be contractual arrangements, no different from trying to figure out how people work on the land. So the public law essentially falls into the public space, and the modifications that you see of its interaction are those which take place when you understand that a simple open access regime falls far short of what you need to have in order to get the maximal use out of these public resources. And that's why the public trust doctrine and all its variations start to take place. And by the time you're done with this issue, you worry about rights of way, you worry about exhaustion of common pool resources and so forth. You worry about the interface between public and private law. If, in fact, you left the Roman riparian system and did modern water law, what you would discover is that the model that they're talking about would not be able to apply to all cases, and you'd start to see different variations on the public law side with water. You'd have riparian rights, reasonable uses, prior appropriation as the three main kinds of systems, and would have to explain the differentiations amongst them. But that is simply an issue that the Romans didn't talk about. So even though much of Roman law kind of carries over, how, you might ask? Well, when you're trying to figure out what people have by way of access, they keep on talking about usufructuary rights. Now, a usufruct is a limited life estate in possession on land, which we'll talk about presently. But what happens is when you're talking about water, you have to find some way to say that people have a right to be there, but that it's not permanent and absolute. So what they do is they borrow one concept, which has perfectly sensible meanings in private law, and then use it in a public law context. And sure enough, all of the modern people who talk about water law as usufructuary rights have forgotten the fact that it was a private law term which they've never heard about, but which is of immense importance when you put that system together.
Let's talk about a very basic question. Who would have had property rights in the Roman law system?
The question is, what one has to ask is, to whom do property rights extend? And this is a little bit tricky because one has to remember the basic structure of family law, in which it turns out that the pater familias basically owns it all. And even in modern societies, mama and papa start to acquire it. But it's widely understood when you're dealing with acquisitions by a legal person that if you're a parent and you owe fiduciary duties of guardianship to your children, when you acquire property, you can't keep it all for yourself, but you engage in sharing within the family so as to essentially maximize the position of each individual in that group, subject to the correlative rights and duties of others. But in terms of dealing with the world, it is generally highly inconvenient to have a situation if daddy or mommy acquires property in which the kids have some kind of an interest, to assume that anybody who wants to deal with the property has to get the minor children to sign off on the deal along with everybody else. So there are rights internal to the family that do not bind strangers. And this happens in other places. So when you sit in a classroom, what I always ask to my students is that you're sitting in this classroom. Now the university wants to sell the building. Could you say, you cannot sell this building because I have a right to this seat in this classroom until the end of the term? And they all look at me like I'm slightly mad, because what they realize intuitively is what happens is when you say you have a seat in the classroom, it means that from one class to the next, if somebody else sits in your seat, you can tell them to leave. And so what it is it deals with horizontal relationships among students, but nobody thinks that it binds the university as owner of the building so it can't sell it. So what we say is you don't have a property interest in the nature of a lease. What you do is you have a contractual interest in the nature of a license, and if the license is terminated, it may well be that you have some kind of correlative right, sometimes for damages, but typically in the classroom situation, move to another room, you get a right to another seat, then we sort of forget about it one way or another. So there's always this kind of two-tier system of property. There's the external facing property where you need very few people to have the rights. And then there's the internal division of property. You have large numbers of people whose rights are temporary and partial in some sense or another. And the series is that anybody who deals with the owner of the property does not have to worry about the situation of the internal division. So if you think of a modern situation in which somebody wants to sell a house, little Johnny can't say, I don't want mommy and daddy to sell this house because I then can't use the playroom downstairs. Sorry, Johnny. What you have to do is you have to move to the new house and look to your parents to give you another playroom, which essentially they will probably do. So essentially what happens is the legal person is the one or two people who are entitled to deal with this. In the Roman system, it would be the paterfamilias. In the modern American system, it would be the proprietor. With family property, often it's jointly owned between husband and wife, at which point you have to deal with both. But generally speaking, they will act as one in normal relationships so the conflicts don't arise. And if they do arise, then what you do is you're going to have this typical divorce problem in which you're faced with the following choice. Do you divide the property in kind, so a husband takes part of it and a wife takes part of it? Or do you sell the whole thing off to a third person and divide the cash? There is an atavistic sense of property which says, well, if I have the property, you can't force me to cash out my interest, so let's have a physical division. But it turns out if you take the modern split-level house, it's not going to work so well to give dad the upstairs and mom the downstairs, particularly if dad can't get upstairs because he doesn't have access to the downstairs. So the modern tendency is to typically sell the asset and then divide the proceeds, typically money, in form so the two parties can go their separate ways. So we do have to know who this proprietor turns out to be. And once that question is settled, then the really hard questions turns out to be exactly what can the deal start to look like? How do we acquire this property? Are there any restrictions on the way in which this thing could be alienated or divided? How are these rights to be enforced and so forth? And it turns out that you can see the same patterns developing, first in the Roman law, then in the medieval English law, and then in the modern law. Because the issue of two-tier property, looking inward and looking outward, is not a particular feature of Roman society or versus modern society. It doesn't depend upon whether or not you have fancy television sets inside the house or simply have to communicate in words. It's a basic fundamental relationship. And the reason why the natural law theories work so well is if you understand how these partitions are made under the Roman system, it takes relatively little alteration to understand how they're going to work in modern times.
Thank you for listening to this episode of the Number 86 lecture series. The spirit of debate of our founding fathers animates all of the Number 86 content, encouraging discussion and critical reflection relative to how each subject is widely understood and taught in law schools and among law students. Subscribe to the Number 86 lecture series on your favorite podcast platform to have each episode delivered the moment it's released. You can also go to fedsoc.org/number 86 for lectures and videos on federalism, separation of powers, the judiciary, and more. That's fedsoc.org/NO86. Thanks for listening. See you in class.